All right, this is State versus Victoria Cox, and is the court's understanding that this will be a plea in this matter?
Yes, sir.
All right, and are you Victoria Cox? Let me get you to raise your right hand and be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, Ms. Erin.
Yes, sir. I do report the court of House 24-469, that is the Colonel Victoria Cox, who charged with count one capital murder, count two kidnapping, and count three sexual battery. She was before the court, she was the prosecutor, because now this is what she was doing, having a claim, count one, she was the rest of the case.
Dismissing count three. So in count two, she will be pleading to kidnapping. All right.
All right, pause right here. This is the moment the entire case crystallizes. When the prosecution confirmed second-degree murder and kidnapping, that tells us this wasn't charged as premeditated murder. But don't mistake that for leniency. Second-degree murder still carries decades behind bars. Question for you watching. Do you think this charge reflects mercy or strategy?
Ms. Fox, the court has been informed that you desire to enter pleas guilty to the charges of second-degree murder and kidnapping in cause number 24-0-469 in the Circuit Court of the First Judicial District of Hinds County, Mississippi. Is that correct?
Yes, sir.
Before I can accept the pleas of guilty, it is necessary that I determine that the pleas of guilty are knowingly, understandingly, freely, and voluntarily made.
This section might sound procedural, but it's actually crucial. The judge is building a bulletproof record, making sure this plea can't be overturned later. Do you understand, is insurance against appeals. Courts do this especially carefully in cases involving extreme harm.
In order to make this determination, I'm going to ask you some questions. If you wish to decline to answer any of my questions, you may do so. Your attorney is standing next to you, and if you would like to discuss with him any of my questions, you may do so. Do you understand?
Yes, sir.
How old are you?
34.
How far did you go to school?
12th grade.
The 12th grade? You completed 12?
Yes, sir.
Are you married?
No, sir.
Do you have any children?
3.
And how old are your children?
9, 8, and 6.
9, 8, and 6. Have you ever worked anywhere?
Yes, sir.
When is the last time you worked?
Right before Henry Joe, I was working at Rest Care.
I'm sorry, you're working.
Rest Care.
Rest care? What is that?
It's like a in-home care facility
And how long have you worked there?
for about 6 months.
Are you right now under the influence of any drugs or alcohol?
No, sir.
Do you understand that at this time the court seeks to determine whether your pleas of guilty are knowingly, understandingly, freely, and voluntarily made in order to determine whether or not to accept your guilty pleas?
Yes, sir.
You understand that?
Yes, sir.
In front of you is a petition to enter plea of guilty. Have you seen this document before?
Yes, sir.
Did you go over the document with your attorney?
Yes, sir.
Do you understand it?
Yes, sir.
Do you have any questions about it?
No, sir.
On the last page, there's a line marked defendant. Above that line, there's a signature Is that your signature?
Yes, sir.
All right, Ms. Erin, it's on the charges, Mr. Defendant.
Yes, Your Honor, statement shows that Victoria Cox or acting wrongful in concert with aiding, assisting, or concurring and others to it Daniel Callahan did on June 13, 2024.
Let's slow this down. What you just heard is a legal theory tying kidnapping directly to murder. That's important because it explains why she can plead guilty to murder even though she didn't physically kill the child. In the eyes of the law, participation that enables a crime can be enough. That's a tough pill, but it's how accomplice liability works.
In the jurisdiction of this court, she did assist, aid, encourage Daniel Callahan and others known and unknown to the grand jury, willfully or lawfully feloniously killing human being Erin Nicole Burnett, a 4-year-old female child whose date of birth is October 28, 2019, without the authority of law by any means or any manner done, without design to effect the death of Erin Nicole Burnett while engaged in the commission of the crime of kidnapping, specifically the kidnapping of Erin Nicole Burnett with any attempt to commit such felony as prohibited by Mississippi Code Section 97-3-2, also in violation of Mississippi Code Section 97-3-19, subsection 2 and E as in count 1. Count 2, based upon a series of acts committed together and or constituting the part of the company's scheme and plan, said Victoria Cox did assist, encourage, Daniel Callahan and others known and unknown to the grand jury on the 13th day of June 2024 in the jurisdiction court, did without lawful authority forcibly seize, kidnap, and or confine JT, a 6-year-old female whose date of birth was October 5, 2017, against her will and or against the will of her parents, guardians, or other persons having lawful custody of her by forcibly confining her at or near 3980 Booker Drive, Jackson, Mississippi. All occurred with the jurisdiction of this court in violation of Mississippi Code Section 97-3-3.
Ms. Cox, did you hear the charges against you?
Yes, sir.
Did you understand the charges against you?
Yes, sir.
Are you admitting that you committed the crimes of second-degree murder and kidnapping?
Yes, sir.
And you're here today to plead guilty to both of these charges?
Yes, sir.
This is the emotional core of the plea. She admits her actions enabled the killing. Not pulling the trigger doesn't mean escaping responsibility. Watch how the judge lets her speak here. This is about establishing guilt in her own words. Do you hear remorse or resignation?
With respect to the first charge, second-degree murder, what happened?
When I brought these girls back,
Hold on, I'm having a difficult time here. Is that my phone over there? Yes, I'm sorry. All right. Go ahead.
when I brought the girls back to Daniel, that enabled him to do what he did and to kill Erin Burnett.
I didn't understand. Just gotta talk a little.
When I brought the girls back to Daniel, that enabled him to do what he did, and he killed Erin Burnett.
Okay, so you brought the girls back to Daniel Callahan?
Yes, sir.
How did you know Daniel Callahan?
I grew up with him when I was younger.
So you indicated that you brought the girls back to Daniel. Where did you get the girls from?
We had just went down the road to get something to eat. We had left where we were.
Now listen to me. Where did you get the girls from?
Yeah, we had left, me and the girls had left Boozer Drive and went and got something to eat. That's where we left.
How did you and Daniel get custody of the girls?
He came and picked me up from my uncle's house in Arcola, Louisiana. And then he had the girls with him.
He had the girls with him when he picked you up?
Yes, sir.
And after he picked you up, what happened?
We came here to Mississippi.
You came here to Mississippi.
Yes, sir.
That question, why did you allow this to happen, is one of the hardest a judge can ask. Legally, fear and coercion matter, but they don't automatically erase culpability. Morally, though, that's where opinions split. Comment below. Is fear ever enough of a reason?
What happened to the girls?
He murdered one of them.
He murdered one.
Yes, sir.
Do you know when he did that?
We were around on the 13th, no, the 4th, the 13th, the morning of the 13th.
So where were you at when this happened?
I was on the property, but I was in the front yard.
You were in the front yard
Yes, sir.
when it happened?
Yes, sir.
Did you know it was happening?
Yes, sir.
How did he murder the child?
Suffocation.
I'm sorry?
Suffocation.
So why did you allow this to happen?
Because I couldn't stop it.
Where was the other child at that time?
I'm not exactly sure.
Did you see the other child again?
No, I've never seen either one of them again.
I'm sorry?
I've never seen either one of them again.
So what did you do after this happened?
I ran as far away as I could from him.
Where'd you go?
I'm not familiar with Mississippi, so I'm not really sure.
You just went down the street?
Yes, sir.
You didn't go to a house? You didn't
No,
go?
sir. I ended up at the OYO hotel.
And about how long afterwards were you arrested?
The next day.
Have you talked to Daniel Callahan since this day?
No, sir.
So since he committed this crime, you've not talked with him?
No, sir.
Why did you commit this crime?
I didn't exactly know what was going to happen.
Said you did not know exactly
know what was going to happen.
what did you think was going to happen? When you brought kids back to Mississippi that did not belong to you, what did you think was going to happen?
Well, up until the incident, I didn't know that he didn't have permission to have them.
When did you learn that he did not have permission to have the children?
Probably about the night before. But I didn't have a phone no more. She took my phone, so I couldn't contact nobody.
Okay. So when you learned that Daniel Callahan did not have permission to have the girls, what did you think would happen? What did you plan to do?
I tried. I wanted to get away, but I couldn't.
Do you know why Daniel Callahan brought the girls to Mississippi?
No, sir.
Do you know why he killed one of the girls?
No, sir.
You have no idea?
No.
And you wish to plead guilty to both of these charges?
Yes, sir.
All right. Does the state have a recommendation in this matter?
Yes, we do. In regards to count one, to say whatever it is, one thing is that they will be proper. In regards to count two, the state recommends 5 years of incarceration or counsel one term.
This is the final crossroads. The judge is making it unmistakably clear. Once this plea is accepted, there is no jury, no appeal, no undo button. Everything from this point forward is sentencing. This is where courtroom reality hits hardest. Quiet, final, irreversible.
Is it concurrent? All right. Ms. Cox, did you hear the recommendation from the state?
Yes, sir.
Do you understand the recommendation?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you understand the minimum and maximum sentences which could be imposed for each of these crimes?
Yes, sir.
And you discussed this with your attorney?
Yes, sir.
Do you understand that for the charge of second-degree murder, the minimum sentence is 20 years?
Yes, sir.
You understand the maximum sentence is 40 years?
Yes, sir.
With respect to kidnapping, do you understand that if the court accepts your guilty plea, you can be sentenced up to from 1 to 30 years?
Yes, sir.
And do you understand that if you went to trial, the jury could assess a life sentence?
Yes, sir.
Do you understand that the court does not have to accept the state's recommendation?
Yes, sir.
And do you still wish to enter pleas of guilty in this matter?
Yes, sir.
Do you understand that if you plead not guilty and went to trial and you were convicted and sentenced, you would have the right to appeal to our Supreme Court?
Yes, sir.
But when you enter a plea of guilty, you give up that right. Do you understand that?
Yes, sir.
Does anybody promise you anything in order to get you to plead guilty?
No, sir.
Anybody threaten you in order to get you to plead guilty?
No, sir.
Then you do understand that you are admitting that you did in fact commit the crimes of second-degree murder and kidnapping.
Yes, sir.
Do you understand you're giving up your rights under the Constitution, which protects you against self-incrimination?
Yes, sir.
And do you understand that if you do not plead guilty, you are entitled to a jury trial, and in order for you to be convicted, all 12 jurors would have to agree on the verdict of guilty?
Yes, sir.
And do you understand that by pleading guilty, you're giving up your right to a jury trial?
Yes, sir.
Do you understand that the burden is on the state of Mississippi to prove you guilty beyond a reasonable doubt if your case went to trial?
Yes, sir.
But when you enter a plea of guilty, you give up that requirement, and the state does not have to prove anything. Do you understand?
Yes, sir.
Under the Constitution, you have a right to be confronted by the witnesses against you. That is, if you plead not guilty and go to trial, the state would have to put on their witnesses, and you would be entitled to cross-examine them. However, when you enter a plea of guilty, you give up your right to be confronted by the witnesses against you, and you further give up your right to cross-examine them. Do you understand?
Yes, sir.
Under the Constitution, you have a right to take the stand and testify on your own behalf. If you do, you will be subject to cross-examination in the same manner as any other witness. You also have the right not to testify, and the fact that you do not testify cannot be commented on or used against you. Do you understand?
Yes, sir.
Mr. Williams, you the attorney for the defendant.
Yes, Your Honor.
Have you talked with her about a petition to enter a plea of guilty?
Yes, Your Honor.
From your observations of her today, do you see anything that will lead you to believe that she is presently intoxicated or under the influence of any drugs?
No, Your Honor.
And from your conversation with her, do you believe that she fully understands what she's doing at this time?
I do.
Have you advised the defendant of all her constitutional rights?
Yes, Your Honor.
Ms. Cox, are you satisfied with the services of your attorney?
Yes, sir.
Has he promised you anything in order to get you to plead guilty?
No, sir.
Do you believe that your attorney has properly advised you about this plea?
Yes, sir.
Do you believe that your attorney has properly represented you in this case?
Yes, sir.
Is there anything further you'd like to say?
Yes, sir.
All right. Does the state have anything prior to sentencing? And no one would like to speak on behalf of it? So there's nothing that you would like to say before sentencing about what you did?
If I can change it all, I would, but I can't.
All right. Ms. Cox, earlier you indicated to me that you had 3 small children.
Yes, sir.
At any point in your mind, were you thinking about your children when you did this violent act? At any point?
Yes, sir.
And that didn't cause you to pause and to probably stop?
I tried, but I couldn't.
And you said that a couple times, so why is it that you couldn't?
Because he was physically stronger
He was
than
what?
I was. Physically stronger than I was.
So when he was in the backyard killing one of the children, you were just up front waiting on him?
No, he had me high that day and
He had you what?
high that
So
day.
you had been using drugs?
He made me,
He made you?
yeah.
Had you used drugs before that particular day? Now listen to my question. Stop talking about it. Had you used drugs prior to this day?
I had been out of rehab for like two days, but I was clean before that. Yeah.
Clean about a day?
No, I had been in rehab for about 2.5 weeks.
So you'd used drugs in the past?
Yes, sir.
Had you used with Daniel Callahan?
Yes, sir.
All right. The court finds that the pleas of guilty of the defendants were intelligently and understandingly made, and therefore the pleas guilty are accepted. And Ms. Cox, the court finds that these acts that you committed, you understand how awful these acts are?
Yes, sir.
You understand how innocent these 2 little girls were? Have you thought about that?
Yes, sir.
And this is something you're going to have a lot of time to think about it.
Yes, sir.
The state has made a recommendation in this matter, and the state makes recommendations after considering all of the facts in this matter. So the court will go ahead and, since the state has reviewed it and looked at all of the circumstances, the court will accept the recommendation of the state with regard to sentences to be imposed on these pleas. Victoria Cox, upon your having entered a plea of guilty to the charge of second-degree murder, you will be sentenced to 40 years in the custody of the Mississippi Department of Corrections. Upon your having entered a plea of guilty to count 2 of the indictment, kidnapping, you will be sentenced to 25 years in the custody of the Mississippi Department of Corrections. The state has agreed to remand count 3 of the indictment, and these 2 counts will run concurrent with each other. Do you understand your sentence?
Yes, sir.
Anything further, Mr. Williams?
No.
Anything further from the state? All right, you can take the defendant in custody.